Hello, everyone, and thank you for attending today's webinar, Employee Benefits Update. I'm Mike Lane, and I'm joined today by several of my partners in our Employee Benefits group for a grab bag of topics. Before we begin, we wanted to cover a few housekeeping items. If you have any questions during the webcast, you can submit them through the Q&A widget at the bottom of your screen. We will try to answer these during the webcast, but if a fuller answer is needed or we run out of time, it'll be answered later via email. A copy of today's slide deck is available in the resource widget. We encourage you to download any resources or links that you may find useful. You can find additional answers to some common technical issues located in the help widget at the bottom of your screen. This webinar is accredited in California and Illinois for 1 hour of general CLE credit and in Missouri for 1.2 hours of general CLE credit. 1 hour of general CLE credit in Texas is pending. This webinar is also accredited for 1 hour of SHRM and HCRI credit. We award CLE based on attendance for the entire 60 minutes. From time to time, you will be required to click a pop-up screen to reflect your continued engagement. Certificates will be sent out to qualified attendees within 48 hours of the conclusion of this webinar. We value your opinions and appreciate your participation in the course. So with that, I will turn things over to Cathy Conrad to kick things off.
Thanks, Mike. I'm going to cover the Secure Act and the CARES Act update. The Setting Every Community Up for Retirement Enhancement Act, or Secure Act, was signed by the President on December 20th, 2019. The Secure Act implemented key retirement plan and IRA legislation reforms, some of which had been in process for numerous years. Most of these changes were effective as of January 1, 2020. The changes for qualified plans included provisions on required minimum distributions affecting all plans, required minimum distributions affecting all plans except defined benefit plans. For 401k plans, there were some changes affecting only safe harbor plans, and one change affecting all 401k plans. For defined contribution plans in general, special withdrawals for birth or adoption, lifetime income, and loan restriction provisions were adopted. For all plans, penalties for reporting failures were increased, and the date to adopt a plan was extended. Some relief was provided for closed defined benefit plans, and multiple employer plans received some long requested relief. So let's get started. The age for required minimum distributions for all qualified plans and IRAs was increased from 70.5 to 72 for individuals who attain age 70.5 after December 31st, 2019. Despite this change, the required actuarial adjustment factor for defined benefit plans remains at age 70.5. The IRS has indicated this was intentional and not a mistake or oversight. And effective for participants dying after December 31st, 2019, the maximum distribution period for designated beneficiaries under IRAs and qualified plans other than defined benefit plans is now 10 years, except for surviving spouses, beneficiaries not more than 10 years younger than the participant, a minor child of the participant until the age of majority, at which time the 10-year rule applies, and disabled and chronically ill individuals. For these individuals, the life expectancy rules still apply. We are waiting on guidance from the service with respect to these new designated beneficiary rules. With respect to the definition of majority, we believe it will most likely be age 18 or 21 based on state law. For safe harbor 401k plans that use a non-elective contribution, the safe harbor notice requirement is eliminated. And a plan can be amended to convert to this type of safe harbor plan by adopting an amendment until 30 days before the end of the plan year. Or, if amended after the 30th day, a non-elective contribution of at least 4% instead of 3% must be made to the plan, and the amendment generally must be adopted by the last day of the next plan year. For 401k plans that use auto-enrollment and auto-increase, the maximum percentage is raised from 10% to 15% after the first year of the deemed election. Effective for plan years beginning after 2020, a 401k plan must allow part-time employees who are age 21 or older and who have worked more than 500 hours for at least 3 consecutive years to make 401k salary deferral contributions to the plan. The plan is not required to make matching contributions with respect to these deferrals or any other employer contributions for part-timers. Even though this change is effective for plan years beginning after 2020, service prior to 2021 is disregarded for purposes of determining eligibility. So the first plan year part-timers will participate is 2024. However, hours of service for years prior to 2021 will need to be tracked. In Notice 2020-68, the IRS advises that all years must be looked at for purposes of determining vesting in employer contributions, if any. Defined contribution plans and governmental 457B plans may be amended to permit an in-service withdrawal of up to $5,000 per qualifying birth or adoption. The distribution must be taken within 1 year of birth or adoption, and the 10% early penalty for distributions prior to age 59 and a half will not apply. The IRS in Notice 2020-68 confirmed that each parent is eligible for the withdrawal, and it applies to each birth or adoptee. An eligible adoptee is defined as an individual who has not yet attained 18 or is physically or mentally incapable of self-support. The individual will be required to include the name, age, and taxpayer identification number of the child or adoptee on his or her tax return for the year the distribution is made. The plan can rely on reasonable representations from the participant. If the plan allows these withdrawals, it must allow recontribution. Even if a plan is not amended to permit these withdrawals, the individual can claim exemption from the 10% penalty tax by filing Form 5329. And the IRS in Notice 2020-62 amended its 402F notices, adding this type of withdrawal to the list of withdrawals exempt from the 10% penalty tax. The Secure Act adopts certain lifetime income provisions, including requiring defined contribution plan benefit statements at least annually to include an estimate of the monthly income the participant's account balance would produce if benefits were received in the form of a qualified joint and survivor annuity or single life annuity, providing a fiduciary safe harbor if lifetime income investment options is included in the plan, and permitting direct trustee-to-trustee or annuity contract transfers without regard to restrictions on in-service distributions. With respect to the new required defined contribution plan participant benefit statement disclosure, on September 18, 2020, the DOL issued the interim final rules that provide the necessary information and model language to be included in participant benefit statements. There is a 60-day comment period that ends on or about November 7, 2020. The DOL has indicated that it intends to issue a final rule sufficiently in advance of the September 18, 2021 effective date. The final rule will supersede the interim final rule. Per the interim final rules, the assumptions that must be used in making the computations are the participant is age 67 or his actual age if older and is married with a spouse of the same age. The mortality table to be used is the IRS unisex mortality table. The interest rate is the 10-year constant maturity treasury, and the annuity commencement date or annuity starting date is the date of the statement. The interim rules contain special rules for plans with in-plan annuities. The DOL notes that this provision does not require a plan that is not otherwise subject to the annuity provisions of the code to include an annuity form of payment. Once effective, this information must be included on defined contribution plan participant benefit statements at least annually. The Secure Act also prohibits the use of credit cards or similar arrangements for plan loans, increases the penalties for plan reporting failures, and provides plans can now be adopted after the close of the tax year, provided the plan is adopted by the filing deadline for the employer's tax return for the tax year. Defined benefit and governmental 457B plans may be amended to allow for in-service distributions commencing at 59 and a half, and non-discrimination and minimum coverage relief is provided to allow continued accruals in frozen defined benefit plans. Access to multiple employer plans was expanded, and certain MEPs were provided protection from the one bad apple rule. On June 18, 2020, the DOL issued a request for information soliciting input on a possible prohibited transaction class exemption for open MEPs and pooled employer plans. The comment period lasted only 30 days and ended on July 20, 2020. The Corona Aid, Relief, and Economic Security Act, or CARES Act, signed on March 27th, provides relief through increased access to retirement plan funds and expanding the preventive services to be covered by group health plans. Retirement plans are permitted, not required, to offer coronavirus-related distributions and loan relief to qualified individuals. Required minimum distributions in 2020 for all plans except defined benefit plans are waived. The rules for 401k safe harbor plans to make mid-year reductions or suspensions of employer contributions was relaxed, and funding relief for single employer defined benefit plans was provided. Under the statute, qualified individuals are defined as participants, beneficiaries, and alternate payees who meet one of the criteria listed. Qualified individuals are permitted to self-certify the need for the distribution or loan, and the plan is not required to confirm which criteria applies unless the plan has actual knowledge to the contrary. In Notice 2020-50, the IRS used its statutory authority under the other factors as determined by the IRS criteria to expand the category of qualified individuals. Notice 2020-50 expands the list to include a participant who has a reduction in pay due to COVID-19, has a job offer rescinded or start date for a job delayed due to COVID-19, or has a spouse or member of his or her household that meets any one of the entire list of the criteria that apply to the participant. The notice also includes an example of an acceptable certification. Coronavirus-related distributions to qualified individuals are permitted during 2020 only. In Notice 2020-50, the IRS confirmed the amount can be withdrawn regardless of need. The individual can claim a coronavirus-related distribution even if the plan does not allow such distributions by filing Form 8915E to report the distributions received. Corrective distributions received cannot be claimed as a coronavirus-related distribution, and if the plan accepts rollovers, it must accept recontributions. Loans to qualified individuals only between March 27th and September 23rd could be made in greater amounts. Loan payments between March 27th and December 31st, 2020 can be delayed for 1 year. Interest continues to accrue, and the delay is not included in determining the 5-year maximum loan term. If implemented, the plan or plan loan policies may also need to be amended to increase the number of plan loans allowed. Many plans limit participants to 1 loan at a time. Also, the sources from which a loan may be taken may need to be modified. Some plans do not allow loans from all or some employer contribution sources. The DOL has provided non-enforcement relief with respect to the increased limits. Again, the IRS in Notice 2020-50 provided some guidance. The suspension period can be less than 1 year. Subsequent payments are to be adjusted with interest during the period of the suspension. The amount is reamortized over the suspension period that is up to 1 year over the original term of the loan, and the reamortized payment is added to the other repayments, both amortized and non-amortized, to construct an overall payment schedule. IRAs, including inherited IRAs and all defined contribution plans, but not defined benefit plans, are permitted to waive required minimum distributions for 2020. This applies to 2020 RMDs and the first-year RMD for a participant who turned 70.5 in 2019 and delayed his or her first payment until April 1, 2020. In certain circumstances, an individual who already took an RMD was able to recontribute the amount to the plan or IRA. If a distribution that otherwise would have been an RMD is made in 2020, the distribution is an eligible rollover distribution, but the eligible rollover distribution rules will not apply. Notice 2020-51 provides the following additional guidance. An extension of time until August 31st, 2020 was granted to recontribute 2020 RMDs already received. Confirms the RMD waiver applies to individuals whose required beginning date is April 1st, 2021. However, that individual must receive a 2021 distribution by December 31st, 2021. Confirms this does not change the individual's required beginning date. Confirms no other Code Section 401A9 deadlines are modified, and that it does not allow for the suspension of RMDs being made under the substantially equal periodic payments method. This notice also includes a sample plan amendment. Notice 2020-52 provides guidance on Safe Harbor 401k plan mid-year election reductions or suspensions. A mid-year amendment to change contributions on behalf of highly compensated employees can be made only if a supplemental Safe Harbor notice is provided and an election opportunity is provided to the HCE. And temporary relief from certain requirements for mid-year amendments adopted between March 13th, 2020 and August 31st, 2020 was provided. Single employer defined benefit plans were provided funding relief by delaying minimum funding payments due in 2020 until January 1, 2021, and permitting use of 2019 funded percentages for 2020 benefit restrictions. Guidance on this relief was issued in Notice 2020-61, and in an announcement 2020-17, the due date for reporting and paying excise taxes on those delayed minimum contributions was extended until January 15, 2021. Further funding relief for defined benefit plans is actively being sought from Congress. Plans need to be operating in compliance with the Secure Act and CARES Act now, but plan amendments for all plans other than governmental plans are not required until the end of the 2022 plan year. One item of additional COVID-19 relief for qualified plans I wanted to mention is Notice 2020-42. This notice provides temporary relief from the physical presence requirement for witnessing spousal consents by a notary or plan representative for the period, and it was retroactive, back to January 1, 2020 to December 31, 2020. To apply, the consent must be executed via live audio-video technology. For a notary, the technology must meet the state law requirements for remote notarization. And for a plan representative, there are additional requirements, like the individual has to present a valid photo ID during the conference, the technology must be interactive, the individual must transmit documents electronically the same day to the plan representative, and the plan representative must acknowledge the document has been witnessed under the notice and must send the signed document and acknowledgement back to the individual. This relief is currently set to expire on December 31st, 2020, unless extended by the IRS. With respect to health and welfare plans, the big change in the Secure Act was the formal repeal of the Cadillac tax, medical device tax, and health insurance provider tax. Before talking about group health plan changes made by the CARES Act, I must first briefly mention the changes required by the Families First Coronavirus Response Act. All group health plans, insured, self-insured, Erisa covered, non-federal government, church, and grandfathered plans are required to cover COVID-19 screening and testing with no cost-sharing, deductibles, co-pays, co-insurance, or other cost-sharing, and no prior authorization or medical management. These costs must include the cost of the provider visit, no matter the location. The CARES Act expanded this provision, and further guidance issued in the form of frequently asked questions issued jointly by HHS, DOL, and IRS on April 12th provided additional guidance concerning these provisions. Group health plans must comply as of March 18th until the public health emergency related to COVID is over. During the public health emergency related to COVID-19, the CARES Act is further clarified by the Tri-Agency FAQs, requires group health plans to cover, again, with no cost sharing and no prior authorization or medical management requirements, additional tests and services, which included in vitro diagnostic testing, including serological tests, and in covering tests that had not yet received full FDA clearance. Items and services furnished to an individual during the healthcare provider office visit, no matter the location or if in person or by telehealth, that resulted in an order for the administration of a diagnostic test were also required to be covered. The plan or insurer must cover the cost of these in-network and out-of-network providers at a negotiated rate with the provider, and if there's no negotiated rate, at the cash price for the services as listed by the provider on a public internet website or at a negotiated rate less than the cash price. HHS has authority to impose civil penalties up to $300 per day on any provider that does not comply. And for plan years beginning on or after December 31, 2028, on or before December 31, 2021, high deductible health plans are permitted to cover telehealth and other remote care services below the deductible without endangering the plan's HSA eligibility. A couple of miscellaneous items of note. The ACA restrictions on reimbursement for over-the-counter medical products without a prescription from a health savings account, health flexible spending account, or Archer medical spending account was repealed. In Notice 2020-29, the IRS issued guidance on increased flexibility for mid-year changes and grace periods to apply unused amounts in health FSAs. And in Notice 2020-33, the IRS modified Notice 2013-71 to increase the carryover limits of unused amounts in health FSAs. Given the layoffs and furloughs that might have been implemented, employers need to be mindful of the ACA employer mandate penalties that might apply if the plan failed to offer coverage to at least 95% of the employer's full-time employees as defined in Code Section 4980H, taking into account the look-back measurement period and stabilization period rules the employer might be using to comply with this rule, and if the cost of coverage did not remain affordable. To date, there has been no relief granted to those penalties. And now Trish Winchell is going to discuss the changes to the summary of benefits and coverage for group health plans effective for plan years beginning in 2021.
Thanks, Cathy. I'm going to spend just a few minutes talking about the revisions to the SBC. It's the one change really of any significance to the typical required annual welfare plan disclosures. And the DOL actually released a revised template late last year for the SBC and issued some FAQs earlier this year. This new template is supposed to be used in connection with open enrollment for plan years beginning on or after January 1st, 2021. So for calendar year plans going through the fall open enrollment, the time to use this new template is now. The SBC, of course, is the summary of key features of plan coverage that has to be provided in a uniform prescribed format, and it can't be longer than 4 pages, double-sided. This requirement came in with the ACA. The purpose is to help consumers compare plans on an apples-to-apples basis. It's required to be distributed with open enrollment materials. It's also required to be distributed within 90 days of a special enrollment, within 7 days of a request, or 60 days in advance of a material plan change that would make a change to the SBC. Although the agencies in guidance earlier this year made an exception to the 60-day advance notice requirement for the changes related to coverage of COVID testing. And the notice requirement for those, or the change required for those, is simply as soon as practical. There's some minor formatting and non-substantive changes, but there are 2 other changes that are of note in the new template. One of the changes relates to the minimum essential coverage disclosure. Both the old and the new template require disclosure of whether the plan being described provides minimum essential coverage as defined in the ACA. And most employer plans are going to answer yes to this question. Then the old template provided that the failure to have minimum essential coverage could result in the employee having to pay a penalty with their income taxes. Since Congress reduced the amount of that penalty to 0, the revised template eliminates that reference to the individual mandate penalty for failure to have minimum essential coverage, and instead it simply lists the types of coverage that are considered MEC, and then provides that if you're eligible for certain types of minimum essential coverage, you may not be eligible for the premium tax credit to subsidize the purpose, or to subsidize the purchase of medical coverage in the marketplace. The second group of substantive changes to the SBC relates to the coverage examples. The SBC has a page that requires disclosure of estimated out-of-pocket costs that a participant might incur if they're either having a baby, if they're managing type 2 diabetes, or if you're treating a simple fracture. And there are changes in the guidance of how to calculate those costs, and changes in the coverage example calculator. And that's a tool that employers and insurers who are completing the SBC can use. They can plug in certain plan terms, and the calculator will spit out the costs that need to be disclosed. And those changes mean that even if your plan hasn't changed, the disclosure of estimated out-of-pocket costs may well change. The FAQs issued earlier this year confirm that plans are not required to use the calculator, but it does provide a safe harbor for these kind of disclosures. The potential penalties for the failure to provide a compliant SBC can really add up. The current penalty under the ACA is $1,176 for each failure, which is for each individual who doesn't get a compliant SPD. And even if you have a fully insured plan and you're relying on your insurer to produce the SBC, that penalty can be assessed. You and the insurer are jointly liable for that penalty. And in addition, the DOL or IRS can impose a $100 a day excise penalty per day per affected individual. So, the template is on the DOL and the CMS websites, and employers should just be sure that the correct form is being distributed with this open enrollment and at all the other required times. And so with that, I am going to turn it over to Lori Jones.
Thanks, Trish. Today I'm going to speak about changes in the disclosure requirements under Erisa for retirement plans. And as you all know, Erisa requires certain disclosures to participants and beneficiaries, such as summary plan descriptions, summaries of material modifications. And the Erisa regulations generally have envisioned those being provided on paper. However, you know better than most that the provision of paper documentation to all the participants and beneficiaries can not only be administratively burdensome, it can be really costly for an employer. Given advancements in technology where you have employees with access to computers and laptops and tablets, plan administrators and employers have long sought relief from the DOL that would allow them to provide these documents electronically. Now, back in 2002, the DOL published a safe harbor which permitted electronic disclosures if certain requirements were met. First, the employee had to be able to effectively access the disclosure at a location where they were reasonably expected to perform their employment duties. Second, the electronic access had to be an integral part of his or her employment. As an alternate, the employer was permitted to give electronic disclosure if the participant or beneficiary consented in accordance with the rules. But the 2002 safe harbor really was a limited use for a lot of employers. You know, some had limited technology in their work locations. Others might have had a significant number of employees whose circumstances of employment did not really involve computers or electronic access. So on May 27, 2020, the DOL issued a final rule that provides two additional safe harbors for the protection of retirement plan disclosures electronically. The first is called the Notice and Access Safe Harbor. The second is the Direct Delivery via Email Safe Harbor. Now, there are a number of key points you have to keep in mind with respect to both of the safe harbors. First and foremost is that the safe harbors as issued do not extend to welfare plans. It's only for retirement plans. And the DOL cites several reasons for this, one of which is that welfare plans, such as health plans, have a number of different requirements that retirement plans don't have to worry about, like access to emergency health care or pre-service claims reviews, things like that. And second, the DOL has to work with a couple of other agencies when it comes to welfare plans, such as the Department of the Treasury and the Department of Health and Human Services. And you can imagine in Washington, just getting one agency to issue a final rule is great, but having three agree to a final rule is pretty amazing. So they decided to issue this rule limited to retirement plans, but they did say they will continue to review the option of expanding it to welfare plans. So hopefully we'll hear some good news on that in the future. A second key point is that the safe harbor is applied to covered documents. Now that's defined as any document that's required to be provided to participants and beneficiaries under Title I of Erisa. It does not include a situation, for example, where a participant or beneficiaries come to the plan administrator exercising their rights under Erisa and saying, I need a copy of the plan document or I need a copy of the insurance policy. Those still cannot be provided electronically by default. A third key point is that the safe harbors apply to covered individuals. Now, this is defined as you would expect it to be to include people like participants and beneficiaries and, say, alternate payees under a qualified domestic relations order, anyone who's entitled to covered documents under ERISA, but the individual has to provide the employer or the plan administrator with an electronic address, such as an email address, or it could be an internet-connected device like a smartphone where you can text them documents. Now, if the employer happens to assign electronic addresses through work for employment-related purposes, that is also deemed to satisfy the final rule. Fourth, in both of the safe harbors, and you'll see this in the disclosures required under the safe harbors, the covered individuals must be able to elect how they want to receive their documents. So they can always request the plan administrator to provide, free of charge, a paper copy of a covered document. In addition, covered individuals at any time have the right, free of charge, to just globally opt out of electronic delivery and say to the plan administrator, I want paper. Now, an important part of both of the safe harbors is the initial notice of default electronic delivery. Prior to relying on either one of the new safe harbors, you must provide to each covered individual a written notice on paper stating that covered documents will be provided electronically. Now, the comments to the final rule, people suggested, well, why can't we just email it to people? And the answer was, look, it's the first time you're telling them that they're going to get documents electronically. We want it sent on paper because we can't be, we want to ensure that they're receiving this notice. The initial notice need only be provided once and can be provided with other documents, which is important. Comments to the rule, some people suggested, hey, we only want to have to provide the notice in connection with all of our other onboarding documents for new employees, for example. Or we want to provide the initial notice in connection with all of our annual enrollment materials. And the IRS, after thinking about it and thinking about all those people who said, no, it really needs to be a standalone, they came down in rare form. They hardly ever do this, but they said, look, we recognize how you guys really work out there. We think it's reasonable to include this initial notice along with the pack of information you give to a new employee, along with the pack of information that you give for annual enrollment, as long as it's in paper, okay? Always remember this particular document has to be on paper. So what must the initial notice include? Well, it has to include the electronic address that the plan administrator is planning on using to send documents, and it's got to include instructions necessary to access the covered documents under whichever safe harbor you're relying on. It has to also include a statement that any covered document, in the case of the notice and access safe harbor where you're posting it on a website, it doesn't have to be up there indefinitely. So there's a length of time that you have to keep it up there, which is typically a year, or if later, the date a subsequent version is posted. So for example, if you're posting a summary plan description on a website, it's got to stay up there until you post the next summary plan description, even though that might be longer than a year period. The initial notice has got to state the right of any covered individual to request paper version of a covered document free of charge and how they can do that. And it has to let them also know that they have the right at any time to opt out of electronic delivery and receive only paper copy of covered documents. Okay, let's talk about the first safe harbor, the notice and access safe harbor. What this permits a plan administrator to do is post required disclosures on a website and also provide a notice of internet availability, which I'll call an NOIA. The NOIA must be provided at the time a covered document is posted. So if you're posting 6 different covered documents at 6 different times, you're going to provide 6 different NOIAs. I will describe some relief to that rule in a minute. But some of the following, but not all, are included in the NOIA. This is a long final rule, so I've only included some of the more important items. So it's got to have a prominent statement that says, maybe in the title or subject line, disclosure about your retirement plan. The statement has to further read that important information about your retirement plan is now available. Please review this information. You're basically trying to hit them over the head with, this is important. Go to this link, read this information. You've got to identify the covered document by name. If, for whatever reason, you think the title is not sufficient to let them know what the document is all about, then you've got to also provide a brief description. Now, an example that's used is, well, you provide an annual benefit statement to people. They know what that is. They've gotten that annually. You don't have to explain it to them. But if you're giving people a blackout notice and you just title it blackout notice, they don't really know the import of it. And some people may have never received a blackout notice. So and that might be an example where you in addition to identifying the document, you provide a brief description. You've also obviously got to provide the website address or the hyperlink at which the covered document will be available. So the NOIA must also, as you would expect and as we discussed previously, describe the right to request paper version free of charge and how to make the request. Also discuss the right free of charge to globally opt out of electronic delivery and in the future only receive paper copies. Again, in the case of this particular safe harbor, you've got to let them know about or caution them about the fact that documents may not be up there indefinitely. So if we're posting a new SPD, the old SPD is going to come off. If they're wanting to keep historical SPDs, they're going to have to print it or else request a paper copy from the employer or the plan administrator. And then finally, you're going to give them a telephone number so that they can contact someone about any questions they might have with respect to the notice of the safe harbor. Now, how is the NOIA provided? Well, unlike the initial notice, which, as I already said, is provided once and it has to be provided on paper, the NOIA must be sent by the electronic address that's been provided. Okay, and it must be sent separately unless you qualified for a combined NOIA. Now, the IRS, some people suggested, well, shouldn't we provide the NOIAs in paper too? And the DOL basically said, look, we think providing the initial notice on paper is enough. We think it's important once you've notified them on paper that we're relying on the safe harbor, you switch immediately to electronic, and we want that NOIA being provided electronically using the procedures you have already described to them. So that's the rationale for that. So when can you provide a combined NOIA? As I said before, you're supposed to issue an NOIA whenever you post a covered document. That can be extremely burdensome. So the final rule did come up for a way in certain circumstances that you can combine covered documents or combine the NOIA for a number of documents you're posting. So it's permitted if the combined NOIA is furnished each plan year and no more than 14 months following the prior year's NOIA. It can cover one of all or all of the following documents: summary plan descriptions listed flat out, or a document that must be provided annually and doesn't require any action on the part of the covered individuals. So what would be examples of those? Well, you would be talking about the SPD, any summary of material modifications, an annual funding notice, maybe some of the investment-related disclosures you're required to give participants, a QDIA notice, the Qualified Default Investment Alternative, and the annual pension benefit statement. Not the quarterly, but the annual. What would be examples of things you would not do on a combined NOIA? Well, that would include, say, a notice of a blackout period, a notice of a qualified domestic relations order determination because somebody's got to take action with respect to that. Maybe the notice of failure to meet minimum funding standards because that's not going to be an annual kind of event. So that gives you some idea of what a combined NOIA would look like. Let's turn to the second safe harbor, which is appropriately called the direct delivery via email safe harbor. And as you would tell by its name, it permits the plan administrator to provide covered documents directly to covered individuals, either in the body of the email or as an attachment to an email. Now, the email must include a subject line that reads, disclosure about your retirement plan. Got to be sent to the electronic address that was provided to the plan administrator. And again, as I mentioned before, if the employer is providing email addresses to employees for employment-related purposes, that's a permissible email address to use. The email must be sent no later than the deadline for providing the document under Erisa. And if you are choosing to attach the covered document as an email, the body of the email must identify the covered document. Again, you provide a description if for some reason the title doesn't accurately convey the nature of the document. You've got to, again, state the covered individual has a right to request free of charge a paper copy, state the right that they have to opt out of electronic delivery, and then, again, provide a phone number of the plan administrator or representative for any questions. Now, it's impossible to cover everything on this presentation today. I'll just note that there are certain requirements for your websites. You know, they got to meet certain requirements. In addition, since we're relying on electronic addresses, if for some reason you've got to design your system so you know if someone's not receiving these documents. So you've got to have some form of bounce back, for example, that will alert you that the email address you're using for a particular covered individual is invalid or inoperable. Once alerted, you've got to do something about it. You've either got to try to fix the email address, or if you can't, you simply can't fix it, then you've got to assume the person opted out of electronic delivery and make sure they get a paper copy. So what's the effective date of all this? Well, it was effective in July, 60 days after publication, but the DOL recognized we're in the middle of a pandemic and said, look, as soon as it was issued, as soon as it was out in print, they said, you can rely on this. We're not going to take any action on anybody who starts relying on these things immediately because they knew you're maybe running a skeleton staff. It's pretty hard to get things done, and so they wanted to make this rule available as soon as possible. I will say that the new safe harbors provide immediately and welcome relief to employers and plan administrators. It can reduce your costs, relieve your administrative burdens. Unfortunately, the IRS has not yet said whether they're going to hop on board with this, this process that's been developed by the DOL, but we hope they will. So what I would, your takeaway from this on this topic, I think, would be to go back, look at your current procedures, and consider whether adoption of one of these two new safe harbors is right for you. I know that there are many employers and plan administrators out there that have already been providing some of these documents electronically because of the cost and because they're getting pressure from the business offices, and they didn't meet the 2002 safe harbor. So I would encourage you, this is the time to take a look at these new safe harbors, go back. The initial notice of availability is not all that burdensome to comply with, and I think it will let you sleep better at night just to know that you're fitting or trying to fit within one of these safe harbors for electronic delivery of documents. So now Mike Lane will discuss timing relief for benefit plans under COVID. Take it away, Mike.
Thank you, Lori. As Lori mentioned, my segment is going to focus on some temporary rules that are in place due to the pandemic relating to certain actions that need to be taken either by administrators or by participants under a wide variety of plans that are subject to Erisa. All right, so what are we talking about when we're talking about the guidance? There's a couple of things that were done. The first, there were regulations that were issued jointly by the Department of Labor and by the IRS. And those joint rules are combined with guidance specifically from the Department of Labor in the form of EBSA Notice 2020-1. And taken together, these rules impact all types of plans and a wide variety of deadlines. They're going to impact what employers need to do operationally, and they're going to impact what employees are allowed to do in terms of making elections. And, if there's one overall theme, I think, to this guidance, it's that these agencies were sort of trying to throw the kitchen sink at the problem of helping participants get or keep health coverage during this pandemic. So focusing first on the relief that applies to participants, there's an important concept that runs through the joint regulations and the EBSA notice, and that is what's called the outbreak period. So the outbreak period starts on March 1, 2020 and ends 60 days after the national emergency ends. So you get an extra 60 days after, the president declares that there's no longer a national emergency. The ending of this is sort of up in the air depending on a couple of things, not only the president's decision, but as we'll talk about in the end, the agencies are a little bit limited in what they're allowed to do under statutes. So this guidance grants additional time for employees to exercise various rights, but as we'll discuss, it can create some headaches for employers. So what specifically are we talking about? Examples of affected deadlines include the deadline to make HIPAA special enrollment in a plan, to elect and pay for COBRA, and all kinds of claims and appeals deadlines, including deadlines to submit claims to health plans for reimbursement, deadlines to appeal adverse benefit determinations, deadlines to file an external appeal with the independent review organization for a health plan. That's under the recent rules due to the ACA that require plans to offer outside review. Well, let's talk about a couple of examples just to give you a little bit more concrete idea of what we're talking about. So let's say you've got an employee who is terminated on April 1st, 2020 and gets that COBRA election notice. Let's say the outbreak period ends December 1st, 2020. We can dream a little bit, but we'll talk a little bit at the end about what happens if this outbreak period drags on further. So first step is you ignore the outbreak period. So the normal 60-day period where an employee gets to elect COBRA gets extended to almost a year out. The employee's got until January 30th, 2021 to elect COBRA, going back to the date that the employee lost coverage, let's call it April 1. So if the employee wants to do that, go that far back, they can. They still have to pay for it. So they would have to pay retroactively for any months that they want to receive this COBRA coverage. So you wonder exactly how many people are going to take advantage of this, but the idea is, hey, let's do what we can to get people coverage. So this also means from an employer perspective and from a third-party administrative perspective, things are going to be held open for a long period of time, and you're not going to know exactly where things are going to shake out until this outbreak period ends. Take another example of a delay here, and this is the time that employees have to pay for COBRA instead of just electing for COBRA. So in this example, the employee elects COBRA effective March 1st, 2020, and they pay for that March coverage timely, but for whatever reason, they choose not to or cannot make payments for any subsequent months. Again, let's assume the outbreak period ends December 1, 2020 in our same rosy scenario. So the employee has the right to pay for premiums for any of those missed months through December 31st, 2020. That means the employee's got coverage. The plan can't deny and push the employee into paying directly for the care until January 1st, 2021. But, the guidance does provide that plans can pay the providers retroactively once they receive payment from the employees. So as you can imagine, this is probably going to cause some headache between plans and providers where you don't know exactly if an employee has COBRA coverage or not because they haven't chosen to pay for it. I'll turn next to what impact this guidance has on employers. As I mentioned, a lot of balls are going to be in the air for a long time until the end of this outbreak period. When the outbreak period ends, whenever that may be, the applicable deadlines that are going to happen or have to happen, the actions that employers and employees need to take, are all going to happen at once. So everything that was up in the air during this whole outbreak period, when the national emergency ends, you add that extra 60 days, all those actions are going to take place relatively quickly. So the question is this emergency going to last into 2021? The agency's authority that they used to issue this guidance allows them to extend deadlines for up to 1 year. So they started the delay March 1. If it goes beyond March 1, 2021, Well, they don't have authority under the statutes to do anything. So I think it's pretty clear that we're going to end up in 2021, but how far, we don't have any clarity. Beyond that, are we going to get more guidance? Will Congress change the law? I mean, all I can say is stay tuned on this to figure out what's going to happen when this outbreak period bumps up against the statutory deadline that these agencies have to do anything about it. All right, so we covered employees and the relief that they get, but what about employers? There's some relief, but it's really far more limited. The relief applies very broadly to all kinds of notices and disclosures, but it's not as easy to take advantage of as the relief for employees. So what are we talking about in terms of relief? Well, basically, the employer gets to delay just about everything required by Title I of ERISA. So that would include your SPDs, your SMMs, your SARs, fee disclosures, annual funding notices, notices relating to COBRA, relating to blackout periods, and 401k plans. That all sounds well and good. But what are the limitations on this? There are strings on it, of course. The same definition of the outbreak period applies, days after the end of the emergency. The plan administrator must act in good faith to provide the notices on a timely basis. Good faith includes sending things by email, by text, via websites, so long as the employer believes participants have access to these methods. So you've got to have a good faith belief that when you send out that email, employees are going to get it. If you do all that, the Department of Labor has said that they will not come in and allege a breach of ERISA for your taking advantage of this guidance. Other operational relief that has been granted includes relief relating to timely payment of employee deferrals and loans into a 401k plan. This has been a big DOL focus in recent years, and a prohibited transaction can result if you hold participant contributions too long. You've got to get them into the plan as soon as possible. The DOL has, however, said that they won't enforce the prohibited transaction rules if contributions are late, but only if it's solely due to the pandemic. So you're going to have to think about how you would need to demonstrate that to the Department of Labor, that it wasn't some other factor that was causing the late contributions, that it was really entirely due to the pandemic. And employers, of course, need to act reasonably, prudently, and in the interest of employees to work as quickly as possible to get those into the plan. Finally, the Department of Labor has said that there is some other operational relief. It seems to be kind of a tough cookie to me. It relates to the CARES Act changes that Cathy alluded to earlier, including the increase in loans to $100,000 and allowing coronavirus distributions of up to $100,000. Under the statute, under the CARES Act statute, plan sponsors have years left to amend their documents to come into compliance with what they did during 2020 under the CARES Act. So what's the DOL saying? Well, they're saying they won't come after you for not complying with your existing policies, even if you don't make an update to them. And to me, I'm not sure why this was really a concern. The statute gave you all this time to amend your documents. Is the DOL saying that without this guidance on timing, that they would go after you for not updating your documents to reflect these increases in loan amounts and the coronavirus distributions? I'm not sure I fully understand this one, but let's just say thank you, Department of Labor, and we'll go ahead and move on. That does it for me. I'm going to pass it on to Rick Pautler, who's going to discuss significant Eighth Circuit ERISA cases.
Good morning. Thanks, Mike. I was going to talk about 3 cases, but maybe time's going to limit us to talk about the first 2, and that's okay. I think the first 2 cases are important because I think they have teaching lessons for all of us who work in this area, and both of them are decisions that were handed down in 2020. The first case is McKinnon versus Meadowvale Dairy Employee Benefits Plan. And in this case, an employee registered in a self-insured medical plan under the name of Cruz. but his real name was Marquez. The decision doesn't ever explain what prompted him to register under an inaccurate name or a false name. But in this instance, the plan provided for a rescission of participation or benefits when a beneficiary committed an act of fraud or made an intentional misrepresentation of material fact. So as luck would have it, Mr. Marquez developed a serious illness shortly after becoming a participant in the plan, and he was hospitalized. His mother signed papers assigning to the hospital all of his rights, remedies, and benefits. The plan denied that claim when he submitted it on the grounds that he had committed a fraud or made an intentional misrepresentation because he had used the wrong name, and therefore it denied all of his claims for benefits. He died without ever filing an administrative appeal. So the hospital took up his claim as the assignee, and the plan denied that claim on the ground that the mother could not assign benefits and that the rescission was in any event correct because of Marquez's fraud. The district court ruled for the hospital. It held that the assignment was valid, that the hospital had exhausted administrative remedies, and that Marquez's fraud was immaterial. But the Eighth Circuit reversed. The court said that because the plan prohibited assignment of benefits, there had not been a benefit assignment. It was impossible to make such a benefit assignment because of the plan provision. But it did say, well, there's a difference between prohibiting an assignment of benefits and prohibiting an assignment of claims. And since this plan only prohibited the assignment of benefits, the assignment of claims was okay. But the problem was there was no cause of action to assign to the hospital because Mr. Marquez had never exhausted his administrative remedies, and therefore there was no claim to be brought in the courts by the hospital. So here are the two lessons I think that we can learn from this case. First of all, it is important, we believe, to include a prohibition against assigning benefits and against assigning claims. This is something we've talked about at our seminars for the past several years. But the other learning point perhaps is that it's also important to include a plan provision that allows you to rescind somebody's participation in the plan or to rescind their right to benefits in the event that they make a material misrepresentation or engage in fraud. Some plans might not want to go that far in the second one. Some may think that this outcome is unjust, but at least this is the teaching of this case. The second case I wanted to talk about is a case called Prawn versus Spire. And this is a case in which I represented Spire, so I've got to tell you that at the outset. But Mr. Prawn in 2010 began experiencing rather significant mental issues. And his superiors at Spire were aware of those mental issues. Nonetheless, Mr. Prawn came into Spire in March of 2010 and quit his job. He said he had better opportunities someplace else. So in 2012, he applied for Social Security disability income and was eventually approved by Social Security in 2016. And the Social Security Administration determined that he had become disabled in February of 2010, which was a month before he resigned his employment at Spire. Once he got in hand the Social Security determination, he submitted a claim to Spire for a disability pension, claiming that he was entitled to that disability pension going back to March of 2010 when he left. The company denied that claim as untimely, basically saying you cannot wait 6 years to file a claim for a disability pension. The plan did not specifically provide an express deadline for submitting the claims, but the committee determined, reading the plan as a whole, it was clear that you had to submit that claim at or about the time you terminated employment. And in fact, the record was clear that that's how the plan had been administered for many years. So it denied the claim and sent a letter to him explaining why it was denying the claim, and also told him that he could submit materials in support of his appeal. And on appeal, he submitted hundreds of pages of medical records for the purpose of proving that he truly had been disabled way back in 2010 before he left employment. Now, there's a regulation under Section 503, and I have it here on the screen. You can read it in its entirety. But what it basically says that a participant has the right to submit documents and comments relating to the claim without regard to whether that information had been provided as a part of the initial claim or not. In this case, the appeal was denied, and the issue in the lawsuit was whether the committee had breached its fiduciary duty by not reading all of those medical records. The committee's position was those medical records may certainly have gone to the question of whether he was disabled, but they had nothing to do with whether his claim was timely under the terms of the plan. And so that therefore it didn't need to wade through all those 1,000 pages of documents. As I argued to the Court of Appeals, if he had submitted the books Gone with the Wind and War and Peace as a part of his appeal, certainly the committee didn't have to read those 2 books before deciding the claim because they had absolutely nothing to do with the issue the committee was deciding. If the committee had decided that his appeal or his claim was timely, then before it could decide whether he was disabled or not, it would have had to read all of those medical records. Well, in this case, both the district court and the 8th Circuit ruled in favor of Spire. And so I think the 2 lessons to be learned here is that when you send out an initial denial letter, the regulation requires that you say that he may submit whatever other materials the claimant might want. But don't make a commitment in that letter that all of those materials are going to be read, because they may not be read, because they may not have any relevance to the issue upon which the committee bases its final decision. And the last lesson of this case, I believe, is if the fiduciary determines that it need not read all of the documents submitted by the claimant, it would be best in the denial letter to explain why all of those materials had not been reviewed. And in this case, we could have done that pretty easily, and it's the argument that persuaded the Court of Appeals. So I think we are at our hour, and I'm going to turn this back over then to Lori.
Okay, thanks, Rick. I don't know that we got a ton of questions. There's one I see with the question of, will we be providing with a sample NOIA? I will say that the DOL considered in its preamble whether or not to issue a model NOIA and basically concluded that there's so many moving parts to it, which safe harbor, what kind of document, the details of what you're disclosing. They opted not to, and I think commenters supported that they did not think a model notice was appropriate. So we we do not have a model, and I think it's going to be based on facts and circumstances, but obviously would be very happy to assist if you have, if you have a draft that you want us to take a quick look at. So as Rick said, we're out of time. If any questions do happen to come in that we didn't have time to answer, we will certainly answer via email. But on behalf of all of our employee benefit attorneys here at Thompson Coburn, I just want to thank you for participating in our webinar today. We greatly miss the opportunity to visit with you in person at our annual HR seminar this year. We'd hope it would be possible next year, but we'll just have to wait and see. I do want to say that we recognize that all of you in HR are on the, are very important and at the forefront of keeping our region going and have had so many issues to deal with, and we appreciate what you're doing. And if there's anything we can do to assist, please know that we stand ready. Also, please complete and submit the survey that we're providing, because we do value your opinions and input and ideas for future webinars. And last, our next webinar in the HR series will take place on next Thursday, October 29th. And I believe the issue is remote work issues and implications. So please, again, thank you for participating and have a great rest of your day. Thank you.